like a barrel of knowledge out of the sky, you're about to get hit with. This episode, Proving Breach and Res Ipsa Loquitur.
Now we move on to proof of breach. It's pretty simple. You need to allege and prove by a preponderance of the evidence that the defendant did something that is different from what the hypothetical reasonable person would do, or different from whatever other standard you're using. For instance, let's say that your theory of breach against a defendant is that they ran a red light, and the reasonable person would not run a red light. So then you have to prove by a preponderance of the evidence that they ran the red light. But if you can't get that done, there's still another potential way to win. Res Ipsa Loquitur. You probably read this case, Byrne versus Boadle, the barrel case. This is the case where the plaintiff was walking down the street in Liverpool and all of a sudden got hit by a barrel falling out of the sky. Now, there was a second-story barrel business above where the plaintiff was. How did the defendant lose control of a barrel that it fell out of their business and hit the plaintiff? The plaintiff doesn't know. The plaintiff couldn't see what was going on in there. Plus, the plaintiff got hit by a barrel. Plaintiff has not got a lot of recollection here. The plaintiff has like a memory blackout of that. The barrel operator's like, hey, this is great. You can't prove breach. You can't tell me where my conduct with barrels departed from that of the hypothetical reasonable person because you don't even know what I was doing with barrels up there. And the court said, whoa, the thing speaks for itself. In Latin, res ipsa loquitur, that's what it means in Latin. The thing speaks for itself. You run a barrel warehouse, the guy was walking underneath, he got hit by a barrel. That speaks for itself. So, res ipsa loquitur applies when the thing that happened is not something that ordinarily happens absent negligence. In other words, there was likely a breach. In other words, there was likely a lack of reasonable care. And the instrumentalities of the accident were in the defendant's sole control, or it was likely that the instrumentalities of the accident were the defendant's. If those two things happen, we can use res ipsa loquitur to establish a rebuttable presumption of breach, so the defendant can still say, okay, fine, I'll turn over my closed-circuit television footage and show you that I was actually being really careful with the barrels, or come forward with some other evidence, if they can, to rebut that. But if it was likely negligence, in other words, likely a breach and likely the defendant, then res ipsa loquitur. The leading application of res ipsa loquitur these days, surprisingly, is not barrel injuries from barrels falling out of the sky, but it does come up with instruments left inside people's bodies after surgery. Take a look at this x-ray. Notice anything going on? Yeah, that speaks for itself. All right, you've had one abdominal surgery. We take an x-ray and this is what we see. Yeah, the people who gave you that surgery, the instrumentalities of this problem were in their sole control. No one else has been inside your abdominal cavity except them. And a pair of scissors wouldn't ordinarily be left inside an abdomen absent someone being negligent. So, res ipsa loquitur. That's a fake image, by the way. I mean, this is a real scenario that does happen, but I cooked that up using the photo manipulation software. That's your breach duty. But seriously, don't come into my office barefoot. This is kind of a problem.